Hello everyone, I welcome you to my channel which is Legal Pedagogy. This is part 1 of important landmark judgments. As you all know, this particular topic is very much crucial if you are preparing for any of the law entrance examination, whether at the UG level or the PG level. So this is part 1 and subsequently all the other parts will be uploaded upon the channel in the near time. So if you want to enroll yourself in my paid live and recorded lectures, you can collect all the relevant information from the contact number which is given on the screen. So let's start with this video. Friends, the first question is, in which case the court held for the first time that the procedure established by law must be just, fair and reasonable. As you all know, Article 21 talks about right to life and personal liberty, but however it can be curtailed if there is a particular procedure which has been established by the law. But however, in the case of Maneka Gandhi versus Union of India, the Supreme Court held that this procedure that we are talking about under Article 21, it cannot be arbitrary and it has to be just, fair and reasonable. So remember this point. This was the case of Maneka Gandhi versus Union of India, and I will request to all of you that you make notes side by side so that in the end you don't have to go through the videos again. The next question is, the right to travel abroad is a fundamental right was held in which case? So friends, in the case of Satwan Singh Sahani versus D. Ramanathanam, Assistant Passport Officer, in this particular case the court held that the fundamental right which has been given under Article 21 as a right to life and personal liberty even recognizes right to travel abroad. So this is a part of Article 21 as held in the case of Satwan Singh Sahani versus D. Ramanathanam, Assistant Passport Officer. The next question is, the right to sleep is a fundamental right was recognized in which case? This right to sleep is very much close to all of us, but however, don't use it against your mothers or the parents that please let me sleep as I have a fundamental right to sleep. So right to sleep was recognized as a fundamental right in the case of Ramlila Maidaan incident versus Home Secretary. If you remember, Baba Ramdev was protesting against the UPA government for the corruption and other things in the Ramlila Maidaan. So on one particular day, the Delhi police took an action while the people were asleep in that particular Maidan. So the court in this case held that the right to sleep is recognized as a fundamental right under Article 21 of the Indian Constitution. So you have to remember this point, and all these landmark judgments which I am covering in this particular video are very much important, are very crucial, and you can support me by sharing this video and by sharing this channel to utmost people. The next question is, the right to life includes the right to live with human dignity was held in which case? So this was a case of Francis Correle versus Administrator Union Territory of Delhi. In this particular case, the court held that the right to life which we talk about under Article 21 is not a bare animal existence. It includes right to live with human dignity, right to live with self-respect. So it was held in this particular case of Francis Correle versus Administrator Union Territory of Delhi. The next question is, in which case the court held that the right to education is a part of Article 21 and the state is under an obligation to provide education at all levels. Friends, this was the case of Mohini Jain versus State of Karnataka. For the first time, the Supreme Court stated that the right to education is a part of Article 21, that is right to life and personal liberty, and the state is under an obligation to provide education at all levels. But however, there was another landmark judgment which came in the form of Unnikrishnan versus State of Andhra Pradesh. In this particular case, the court fixed that from an age 6 to 14, that is elementary education, must be free for everyone. The state is under an obligation to provide free elementary education to every student who falls in this age group of 6 to 14, and there is a fundamental duty which is casted upon the parents to provide elementary education to their wards by sending them to the schools. So just remember the difference between the two. In the Mohini Jain, it was stated that state is under an obligation to provide education at all levels, but however in the case of Unnikrishnan versus State of Andhra Pradesh, the court held that the state is under an obligation to provide free elementary education to the students between the age group of 6 to 14. The next case is in which case the court held that the execution of death sentence in public place is a violation of Article 21. So it was the case of Lakshma Devi versus Attorney General of India. The court held that if a particular person has been awarded the death sentence, but however the execution of this death sentence cannot take place in public place as it is a violation of Article 21. तो अगर आपको फांसी की सजा हुई है तो पर आपकी फांसी की सजा को लटकाया आपको नहीं जा सकता समाज के सामने, पब्लिक प्लेस में आपको नहीं लटकाया जा सकता है। ये कहा गया था लक्ष्मा देवी वर्सेस अटॉर्नी जनरल ऑफ इंडिया के केस में कि वो आर्टिकल 21 का एक तरीके से वायलेशन होगा। द नेक्स्ट केस इज द राइट टू लाइवलीहुड इज अ फंडामेंटल राइट वाज हेल्ड इन व्हिच केस? So it was the case of Olga Tellis versus Bombay Municipal Corporation. In this particular case, the court held that the right to livelihood, right to earn a livelihood, is recognized as a fundamental right under Article 21 because without earning a livelihood, the person cannot survive and cannot live a good life. So therefore, it is recognized as a fundamental right under Article 21. So Olga Tellis versus Bombay Municipal Corporation का केस था जिसमें दोस्तों ये बताया गया कि राइट टू लाइवलीहुड एक फंडामेंटल राइट है जिसको 21 के तहत आपको सुनिश्चित किया गया है। तो ये बात आप याद रखिएगा। अगला क्वेश्चन है राइट टू फ्री लीगल एड इज अ फंडामेंटल राइट वाज हेल्ड इन व्हिच केस? फ्रेंड्स, द राइट टू फ्री लीगल एड which means that if you cannot afford an advocate because of your economic condition, so there is an obligation upon the state to provide an advocate so that you can defend your case. So this is the free legal aid right which has been guaranteed to you. So it was the case of Hussainara Khatoon versus State of Bihar in which the court held that the right to free legal aid is a fundamental right. So this you have to remember, it is even a DPSP. So Hussainara Khatoon versus State of Bihar के केस में कहा गया था कि राइट टू फ्री लीगल एड एक फंडामेंटल राइट है जो कि एक ऑब्लिगेशन है स्टेट के ऊपर कि अगर कोई इंसान अपनी आर्थिक स्थिति के कारण कोई वकील नहीं कर पा रहा है तो ये जिम्मेदारी स्टेट की है कि उसको वकील प्रोवाइड किया जाए। अगला कैसे in which case the Supreme Court allowed the live streaming of court proceedings. So friends, this was the case of Swapnil Tripathi versus Supreme Court of India in which the court gave the green signal that even the live streaming of the court proceedings can be allowed, especially if it is a case related to national interest. So this was a particular case of Swapnil Tripathi versus Supreme Court of India. इस particular case में Supreme Court ने बोला कि कोर्ट प्रोसीडिंग्स जो चलती हैं कोर्ट्स में उनको लाइव स्ट्रीम भी किया जा सकता है। द नेक्स्ट क्वेश्चन इज इन विच लैंडमार्क केस द कोर्ट हेल्ड दैट द स्मोकिंग इन अ पब्लिक place or an area is not permitted as it violates Article 21. So it was a case of Milind S Deora versus Union of India in which there was a complete ban which was imposed that no smoking would be permitted in public areas, in public places like restaurant, hotels, cinema halls and all the other public places like education institutions. So it was the case of Milind S Deora because the court held that allowing the smoking in a public area is a violation of Article 21 for the other person who is standing behind him, beside him, as he would be a passive smoker. So that is why the smoking was prohibited in public places, and if you are smoking in a particular public place, even the challan can be imposed, a fine can be imposed upon you. So it was the case of Milind S Deora versus Union of India. इस particular case में दोस्तों रोक लगा दी गई थी कि public place में जैसे कि होटल, रेस्टोरेंट, एजुकेशन इंस्टीट्यूशंस, यहाँ पे किसी को भी सिगरेट पीने की आज़ादी नहीं होगी क्योंकि जो इंसान उस धुएं को कंज्यूम करता है, बाकी जो पैसिव स्मोकर बनता है वो उसके आर्टिकल 21 को वायलेट करता है। तो ये थे कुछ इंपॉर्टेंट लैंडमार्क केसेस जो आप सभी को याद रखने हैं इफ यू आर प्रिपेयरिंग फॉर एनी ऑफ द लॉ एंट्रेंस एग्जामिनेशन। इफ you like the content, so kindly like the video, subscribe the channel and share it to as much as people you can. Thank you so much.